Indeed, based on the court's careful consideration of the testimony given at the evidentiary hearing, the misrepresentations by Werner and Monahan were sufficiently egregious that perjury prosecutions would, and perhaps should be, an appropriate consideration. Hello everyone, I'm Leonard French, your favorite copyright attorney, and I'm here with a huge update in the Purple Mattress lawsuit. This is the case where Ghostbed is accused of running an illegal smear campaign against Purple Mattress through Ryan Monahan's website at honestmattressreviews.com. The case was filed February of 2017 after Ryan Monahan and honestmattressreviews.com put out an article questioning the safety of Purple Mattress products, which use an anti-tack powder inside the mattress. This article allegedly included many false and defamatory statements intended to damage Purple Mattress's reputation by alleging that this powder was unsafe. Purple Mattress had asked the court for a restraining order, forcing Monahan to remove the misleading material from honestmattressreviews.com while the case proceeds. The defendants opposed the restraining order, saying that there was no affiliation between Ghostbed and Ryan Monahan, but Purple Mattress maintained the position that Monahan was secretly working for Ghostbed and that the honestmattressreviews.com website was used to illegally mislead customers about the safety of Purple's products and the independence of Monahan's reviews. Purple was so insistent about this connection that it pursued an investigation and found evidence of such a connection from Ghostbed's former director of marketing. Purple requested sanctions or punishment for defendants' alleged lies and misconduct. Let's see what the judge has to say about that. So this is the judge's memorandum, decision, and order in the Purple Innovations versus Honest Reviews, Ryan Monahan, and Ghostbed case. Before the court is plaintiff's motion for sanctions. In its motion, plaintiff requests sanctions for defendant's submission of misleading and false statements to the court in opposing plaintiff's request for preliminary injunction. Plaintiff is a manufacturer of bed-in-a-box mattresses and other bedding products. Plaintiff advertises and sells its products solely through an e-commerce platform rather than maintaining brick-and-mortar stores. Because plaintiff relies strictly on an e-commerce strategy, online comment and review websites can have a significant impact on plaintiff's business. In January 2017, a new mattress review website, honestmattressreviews.com, owned by defendant Honest Reviews and operated by HMR's sole owner, Ryan Monahan, began to post reviews of various mattress and bedding products. HMR's reviews or articles about plaintiff's products suggested a link between a white powder used on some of plaintiff's products and cancer-causing agents. For example, one article compared the powder to a ground-down plastic mustard container or glass Coke bottle, which consumers will inhale every night for 8 to 10 hours. The article alluding to plaintiff's product also included a video of the cinnamon challenge in which people were coughing, gagging, spitting, crying, and choking on cinnamon. Plaintiff received low marks on the site, including an image of a large red X, while its competitors, including defendant Ghostbed, received favorable marks. The website repeatedly stated that it was not influenced by any mattress company and that it did not receive financial compensation for its reviews. Some of those statements included that HMR receives 0 affiliate commissions, does not have any affiliate commission sales relationships with mattress companies, and is free from corporate or conglomerates that silence and shape editorial narratives and truths. The site also asserts that the posts on HMR have total editorial independence for which no one has influence. The HMR website also stated that it is not interested in influencing a purchase decision to promote a company or in a few large companies controlling the narrative. Plaintiff filed its complaint on February 24, 2017, alleging claims for false advertising and false association under the Lanham Act and Utah common law, tortious interference with economic relations, defamation, trade libel, injurious falsehood, civil conspiracy, and violation of Utah Truth in Advertising Act. Plaintiff alleged that the statements made about its products, including their connection to cancer-causing agents, are false. Plaintiff also alleged that the statements on the HMR website regarding its intellectual and financial independence from any mattress company are false, and that Monahan, the sole owner and operator of HMR, was closely affiliated with plaintiff's direct competitor, Ghostbed. Accordingly, plaintiff concluded that HMR's purported reviews were actually commercial advertising and promotion that materially misrepresented the nature, characteristics, and qualities of plaintiff's products while failing to disclose the close affiliation with its competitor. On February 27, 2017, plaintiff requested an ex parte temporary restraining order to prohibit defendants from posting false or misleading statements regarding its products. The court originally denied plaintiff's motion for relief, holding that the plaintiff had failed to meet its burden. Following entry of that order, plaintiff's attorney submitted an additional declaration outlining multiple efforts made to notify defendants of the case, including indications that defendants had received actual notice and that defendants appeared to be avoiding service of process. Based on this showing, along with plaintiff's evidence of a strong showing of an affiliation between defendants and a substantial likelihood of success on the merits, the court entered plaintiff's temporary restraining order on March 2, 2017. The following day, on March 3, 2017, plaintiff filed a motion for order to show cause why defendants should not be held in contempt. In that motion, plaintiff argued that defendants had failed to comply with the temporary restraining order and had instead posted an inflammatory article about the lawsuit on the HMR website. Defendants opposed the motion and filed motions to dissolve the TRO on March 9th. In support of their motions, defendants submitted two declarations, the declaration of Mark Werner and the declaration of Ryan Monahan. In his declaration, Mark Werner, CEO of Ghostbed, stated that Ghostbed does not have any affiliation whatsoever with co-defendants Honest Reviews LLC or Mr. Monahan. Werner stated that Ghostbed does not own, operate, direct control, or contribute to honestmattressreviews.com, and that Ghostbed does not remunerate Mr. Monahan or Honest Reviews LLC in any way for anything they do in connection with honestmattressreviews.com website. Werner affirmed that Mr. Monahan is not and has never been an employee, director, or officer of Ghostbed, and that when Mr. Monahan identified himself on Twitter and LinkedIn as Chief Brand Officer of Ghostbed, he did so mistakenly. Werner further stated that Monahan is not a member of Ghostbed's marketing department or any other Ghostbed department, and does not have an office, phone extension, or email address with Ghostbed. Werner stated that Monahan has no monetary interest in the success of Ghostbed and receives no compensation, either directly or indirectly, from Ghostbed for the content he publishes on honestmattressreviews.com. Werner acknowledged Ghostbed's connection with Monahan in only one paragraph, stating that Ghostbed uses Achieve Marketing for branding and marketing consultation services, and that in the past Achieve used another entity, Social Media Sharks, to consult on online presence issues for its client, including Ghostbed. Werner acknowledged that Social Media Sharks is associated with Monahan, but did not acknowledge any current relationship between Ghostbed and Social Media Sharks or Ghostbed and Monahan. Monahan's declaration similarly disavowed any significant business relationship between Ghostbed and Monahan. Monahan stated that he is the sole member and president of Honest Reviews LLC, which operates honestmattressreviews.com, and the founder, co-owner, CEO of Social Media Sharks, a Florida marketing company. Monahan stated that defendant Ghostbed currently contracts with Achieve Agency to perform social media marketing. Achieve Agency in turn engages Social Media Sharks to provide a portion of those services. Social Media Sharks provides similar services to over 25 other companies. Although Monahan admitted that he identified himself as Chief Brand Officer of Ghostbed on LinkedIn, Twitter, and at a conference in September 2016, he stated that he did so without Ghostbed's knowledge and that Ghostbed scolded him for doing so and insisted that he stop. Monahan also stated that he has never had an office or phone extension with Ghostbed. Monahan similarly disavowed a financial relationship between Honest Mattress Reviews website and Ghostbed. He stated that the website has a single source of income, Google AdSense, and that Honest Reviews LLC has never received any consideration or money from Ghostbed, nor has any company, person, or product had any influence over reviews on the HMR website. The court held a hearing on the motions regarding the temporary restraining order on March 14, 2017. At the hearing, counsel for the defendants reiterated the content of the declarations submitted by their clients. Mr. Randazza, counsel for Monahan, strongly argued that Monahan was an independent journalist entitled to full protection of the First Amendment. Mr. Randazza repeatedly referred to Mr. Monahan as a consumer journalist and consumer reporter, even asserting that the court did not have authority to find otherwise. He referred to the HMR site as a consumer journalist publication just like Consumer Reports. With respect to the allegation that Monahan was in fact closely affiliated with Ghostbed, Mr. Randazza stated, "If we believe this entire conspiracy, that this whole thing was cooked up back in October to be a shadow marketing campaign for Ghostbed, that would require a degree of creativity and just a degree of plotting that even Alexandre Dumas could not have imagined when he wrote The Count of Monte Cristo," and stated that these fantasies are probably best used in fiction. Mr. Randazza's coy acknowledgement of a relationship between Monahan and Ghostbed was only in passing. "We have a contractor who is a contractor to a contractor, and we have no desire to hide that relationship." Mr. Randazza referred to the alleged close relationship between Monahan and Ghostbed as a very convoluted conspiracy theory that just does not make any sense. Counsel for Ghostbed, Ms. Yost, similarly indicated that no relevant business relationship existed between Monahan and Ghostbed. Ms. Yost referred the court to Werner's declaration testimony that Ghostbed does not compensate the website owner, which is Honest Reviews, or Monahan in connection with that website. Ms. Yost further emphasized neither Honest Reviews nor Monahan have been compensated by Ghostbed to produce this website or any of the content on it. Ghostbed has declared under the pains and penalties of perjury that it had absolutely nothing to do with the posts before or after the TRO was entered. Ms. Yost acknowledged an attenuated relationship between Monahan and Ghostbed, stating that Monahan is a marketing consultant and he works for many organizations and clients, including Ghostbed. However, Ms. Yost argued that Ghostbed was no different from any other of Monahan's marketing clients, and that the two sworn declarations say that there is no money trail between Ghostbed and the website where Purple's harm is happening. Based on the strong representations from both Werner and Monahan and their lawyers' arguments regarding the absence of a relevant current business relationship between them, the court dissolved the temporary restraining order. On May 24, 2017, plaintiff filed a motion for preliminary injunction, which was based on evidence and a request for relief similar to that in the original restraining order. Plaintiff did not appear to have sufficient new evidence to support the entry of a preliminary injunction. However, approximately 1 month later, on June 28th, plaintiff submitted a supplemental memorandum in support of its motion, attaching a newly obtained declaration from Ghostbed's former director of marketing, Ms. Kalisha Anderson. In that declaration, Ms. Anderson confirmed the bulk of plaintiff's suspicions regarding the relationship between Monahan and Ghostbed. In her declaration, Anderson explained that she was employed as director of marketing of Ghostbed from October 2016 until June 7, 2017. Shortly after beginning her new job, she learned she had very little actual authority for Ghostbed's marketing, and Monahan was the real director of marketing. Monahan controlled every aspect of the Ghostbed website from before the time Ms. Anderson was hired until the day she left Ghostbed. Monahan was on the agenda for every weekly staff meeting Ms. Anderson attended. Monahan attended Ghostbed's staff meetings telephonically and led the discussion regarding marketing. Monahan frequently used the email address ryan@ghostbed.com to communicate with others, including in the system used to send out email blasts. Monahan was the chief brand officer of Ghostbed, and he held himself out as such in his communications with others. During Ms. Anderson's employment, Monahan spoke on the telephone regularly with Werner and visited Ghostbed's offices from time to time. Shortly after being hired, Ms. Anderson was informed by CEO Werner's daughter, Ashley Werner, that Ryan was the real director of marketing and that Monahan's marketing decisions trumped Ms. Anderson's marketing decisions. Monahan could and did on several occasions veto Ms. Anderson's decisions. Based on Ms. Anderson's observations and experience, she suspected that Monahan is being paid under the table by Ghostbed. Ms. Anderson's declaration also provided support for the proposition that Ghostbed independently made statements substantially similar to those alleged in the complaint. She stated that CEO Werner would tell Anderson and other Ghostbed employees about a powder on plaintiff's mattress, saying that a competitor was using talcum powder and talking about lawsuits against Johnson & Johnson because talcum powder caused cancer. Ms. Anderson further stated that she believed that Werner wanted consumers to know about this. The court held a hearing on the preliminary injunction motion July 7th. At the hearing, counsel for the defendant strongly disputed Ms. Anderson's declaration. Mr. Randazza stated, "I realize if you look at Ms. Anderson's declaration, boy, that looks really compelling. It is lies. I'm going to prove it is lies. I hope she'll be charged with perjury when I can show she has lied." In light of the directly conflicting declaration testimony before the court determined that an evidentiary hearing would aid the court in ruling on the pending motion, particularly in determining the nature of the relationship between defendant Ryan Monahan and defendant Ghostbed. Accordingly, the court ordered the 3 witnesses who submitted declaration testimony to appear at an evidentiary hearing for purposes of cross-examination. The court held the evidentiary hearing on September 16th. At the hearing, the court heard testimony from Mark Werner, Ryan Monahan, and Kalisha Anderson. The evidence elicited at that hearing from all witnesses established, among other facts, that Monahan continues to provide extensive marketing services to Ghostbed. Monahan's company, Social Media Sharks, has received over $130,000 from Ghostbed and continues to receive $10,000 per month for Monahan's services to Ghostbed, of which Monahan receives approximately half. Monahan used the title Chief Brand Officer of Ghostbed with Ghostbed's knowledge and without protest, and Monahan helped Ghostbed place competitive ads that targeted plaintiff. At the conclusion of that testimony, the court determined that Monahan and Werner had materially misrepresented the relationship between HMR and Ghostbed, as well as Monahan's status as an independent journalist. The court found the testimony of Ms. Anderson to be credible and persuasive, and was not seriously challenged by cross-examination. After considering all the evidence presented to the court, particularly the close relationship and substantial financial ties between Monahan and Ghostbed, the court entered the preliminary injunction. On October 25th, plaintiff filed its motion for sanctions. Plaintiff argues that defendants' willful misrepresentations prejudiced plaintiff's case and interfered with these proceedings. Plaintiff accordingly requests the court strike defendants' answers and defendants to plaintiff's complaint, grant judgment in favor of plaintiff, and dismiss Ghostbed's counterclaim against it. Defendants maintain that none of the challenge statements were willful, intentional, made in bad faith, and that they do not rise to the level of sanctionable conduct. District courts have very broad discretion to exercise their powers to sanction a full range of litigation misconduct that abuses the judicial process. However, dismissal of a case is severe and should be imposed only when a lesser punishment will not serve the ends of justice. The 10th Circuit has provided 5 factors for a court to consider in determining the appropriateness of sanctions: the degree of actual prejudice, the degree of interference with the judicial process, the litigant's culpability, whether the litigant was warned, whether lesser sanctions would be effective. These factors provide a flexible framework to adequately punish the defendant's misconduct, remedy the prejudice to and harm suffered by the plaintiff and the judicial process, deter future litigants from engaging in this type of misconduct, and engender the public trust in the integrity of the judicial proceedings. The court finds that the plaintiff was significantly prejudiced by defendants' misrepresentations in this action. Plaintiff sought and obtained a TRO in this matter, which was dissolved by the court due to the strong representations of Werner and Monahan and their counsel that they did not maintain a relevant business relationship and that Monahan was an independent consumer journalist. However, the evidence at the evidentiary hearing showed an entirely different picture. Monahan continues to maintain a significant business relationship with Ghostbed and during the relevant time period effectively acted as its head of marketing. When presented with the truth regarding Monahan and Ghostbed's relationship, the court reinstated the injunctive relief initially requested by plaintiff. Plaintiff was deprived of this injunctive relief in the interim and was required to expend time and resources to obtain the requested relief a second time. The court also finds that the degree of interference with the judicial process here was substantial. Defendants and their counsel adamantly defended misleading representations that Monahan and Ghostbed had no meaningful association and that Monahan was a consumer journalist entitled to the fullest possible protection of the First Amendment. They vigorously asserted those misrepresentations even after the court received Ms. Anderson's declaration, which caused the court to hold a full-day evidentiary hearing to determine the truth. Such a hearing could have been avoided had defendants been honest and forthcoming regarding their relationship in the first instance. Defendants now acknowledge that the misrepresentations lacked the level of candor and attention to detail necessary to ensure that all of the material facts were clearly stated and understood by all parties and the court, but claim they were made in the heat of battle. While the court appreciates defendants' acknowledgement of some responsibility, the court does not agree that these material misrepresentations were merely inadvertent missteps. Monahan, Werner, and counsel for each were given numerous opportunities in several hearings prior to the September 16th evidentiary hearings to correct and clarify their previous misleading testimony. Instead, defendants doubled down on their statements and continued to actively conceal the truth from plaintiff and the court. Werner and Monahan actively misrepresented the nature of their relationship for months. These misleading statements could not be reasonably classified as mere oversight. The court did not explicitly warn defendants that misleading the court by sworn testimony was sanctionable conduct, but it could hardly be expected that such a warning would be given. It is expected and presumed that parties and their counsel will not knowingly misrepresent material facts to the court. The declarations of Monahan and Werner were signed under penalty of perjury, and counsel, as officers of the court, are under strict ethical rules to be honest in all of their dealings with the court and to never assist in the subordination of perjury. Mr. Randazza's statements at the July 7, 2017 hearing that he would expose Miss Anderson's statements to be lies and that he hoped there would be sanctions and she'll be charged with perjury when he could show how she has lied demonstrates a clear understanding that submitting a false declaration to the court could result in sanctions. Indeed, based on the court's careful consideration of the testimony given at the evidentiary hearing, the misrepresentations by Werner and Monahan were sufficiently egregious that perjury prosecutions would, and perhaps should be, an appropriate consideration. All of the previous factors weigh in favor of assessing sanctions against defendants. The court must now determine whether a sanction less than dismissal would remedy the harm to plaintiff and deter the errant parties from future misconduct. Dismissal is an extreme sanction that should be used as a weapon of last rather than first resort. Only when the aggravating factors outweigh the judicial system's strong predisposition to resolve cases on their merits is dismissal an appropriate sanction. Here, the court does not find that case-terminating sanctions are the only appropriate remedy for defendants' misconduct. However, given the egregious nature of Werner's misrepresentations, the court finds that striking Ghostbed's counterclaims is appropriate. Furthermore, sanctions will be, and hereby are, awarded for plaintiff's reasonable attorney's fees and costs expended in pursuing its second motion for preliminary injunction, and this motion for sanctions. Defendants Ryan Monahan and Honest Mattress Reviews shall jointly pay 1/2 of those fees and costs, and Ghostbed shall pay the other half. The court will also issue an adverse jury instruction if deemed appropriate when this case goes to trial. For the foregoing reasons, defendant Ghostbed's counterclaims are hereby stricken, and sanctions are awarded for plaintiff's reasonable attorney's fees and costs in pursuing its second motion for preliminary injunction and sanctions, and an adverse jury instruction shall be given if deemed appropriate at the time of trial. Holy mackerel. Just in case you're wondering, an adverse jury instruction is like telling the jury about this, basically. The judge will find some appropriate way to instruct the jury on this. Jury instructions are kind of complicated, so we're not going to cover them here, but this is remarkable. You don't usually see parties trying to get away with this kind of dishonesty before the court. It's one thing for this kind of corporate smear campaign to go on and somebody to get caught involved in a way they shouldn't be. In this case, Ryan Monahan obviously has connections to Ghostbed, when for months, for the past year, he's been saying that he doesn't have any of these connections, including to the court in sworn statements. I mean, there's a reason why they're sworn statements. Like, we had a president get half impeached because of this, remember? You don't lie in sworn statements. It's not a good idea. And so they got caught this time, and it turns out that all of this discrediting that Ghostbed and Monahan tried to do, to me it really only discredits Ghostbed and Honest Mattress Reviews and Ryan Monahan. If you go to the Honest Mattress Reviews website, it still has a disclaimer at the top from the court's order telling the whole world about how the case is proceeding and how the Honest Mattress Reviews website has not been as honest as they claim to be, and they are not as independent as they claim to be. So this sort of misleading consumers is actually not legal. Just because we live in a capitalist society or country or culture does not mean that you're allowed to go lying to people about competitors' products in order to make your product look better. And there are rules about dishonesty before the court as well. Once you're in court and once there are official sworn things going on, you have a duty to be candid, to be honest with the court, and to not lie to the opposing party. If you don't want to answer a question, you go to court and you try to get the right not to have to answer the question. But if you are ordered to answer the question, you don't lie to the court. You can end up in a lot more trouble, and you can certainly discredit your case if you don't remain candid and honest with the court. It's also an ethical duty of lawyers. Believe it or not, lawyers are not allowed to lie to the court or even really lie to the public or to the opposing party. It's not judicially efficient, and it's not becoming of an attorney, and it doesn't give us a good name or make us look good for the public. I'm sure you all know some scumbag attorneys. So this is an image that the industry is constantly trying to shake off, and we have ethical rules that say we're not allowed to do those things. We're not allowed to be false or misleading in our advertising. We're not allowed to be dishonest with the court, and we're not allowed to mislead our clients or even opposing parties in illegal ways. So this is a really big deal. These attorneys and these parties on the defense side, they really should not be conducting themselves this way. I'm hoping this was restrained just to the parties and that these attorneys had absolutely no idea that they were participating in this scheme. But I mean, this is just really egregious that these people would try and pull the wool over the court's eyes too. So we're gonna hear sometime in the near future what these attorneys' fees and costs are. We're gonna hear about an adverse jury instruction, and we're gonna hear about any perjury charges that come down. So you know who I am. I'm going to be reporting on this for you. I'm Leonard French, your favorite copyright attorney. I love you very much. Have a good one, a great weekend, and I'll see you in my next video. We could always use your support over on patreon.com/ljfrench. We also have sponsus.org/law. And if you would like to try audible.com, you can go to audibletrial.com/lawfulmasses and sign up for a free trial there. That helps the channel out. Thank you for all of your wonderful support and participation, and I'll see you in the next video. There should be something up on the screen here. Maybe you can click on that too. See ya.